Right. So last week we sort of like had a look, basic idea about about how fundamental rights work. So in last week's class, basically what we looked at was how fundamental rights work in Sri Lanka. Right? We compared the 72 fundamental rights, 72 constitutional fundamental rights with the 78 constitutional fundamental rights, because 72 constitution fundamental rights lacked a legal protection, if you all remember, right? So 72 constitution said you have rights, but if your rights are violated, there's nothing you can do about it. So we simply call that a constitutional decoration. That was like the icing you put on a cake. It was just there to make the constitution look good. People didn't receive any legal protection out of those rights. And compared to that, the 1978 Constitution did provide a fundamental rights chapter with some legal protection, and that was enforceable. So 78 Constitution had a better fundamental rights chapter. Okay. Then we check what sort of protection methods, what sort of protections we have available in case if our rights are violated, right? So under that, we saw that we have three options. Either we can go to the Supreme Court, or we can go to the Ombudsman, or we can go to the Human Rights Commission of Sri Lanka. Now we saw the fundamental rights petition can be filed to the Supreme Court as provided by Article 17 and Article 126 of the Constitution. You can file a petition to the Supreme Court of Sri Lanka, right? And the Supreme Court may give a judgment whether if your rights are violated or where rights are about to be violated in that case. Okay. So then if going to courts doesn't really work for you, you have the other option of going with the Ombudsman, right? Then you have the other option of going to the Human Rights Commission of Sri Lanka. So I think we were in the midpoint of Ombudsman, right? So what we need to do is we sort of need to refresh our memory as to where we stand in the subject, right? So let's just refresh the memory by reading where we were in the last class, right? And we'll continue from that point onwards today, right? Okay, can we get someone to read the note? Nashita, will you be able to read the note? Does your mic work? Are you well today?
Yes, sir.
Okay, go ahead.
Fundamental rights. Fundamental rights were introduced to Sri Lanka for the first time under the 1972 First Republican Constitution. Therefore, the 1972 Constitution can be considered as one of the important landmarks in the Sri Lankan constitutional history. However, despite this being a bold political feature, this fundamental rights chapter lacked a legal protection framework, which made the entire constitutional chapter a mere constitutional declaration. In general, it was argued that this chapter was simply a declaration of citizen rights rather than a constitutional fundamental rights. Therefore, 1978 Constitution introduced a new fundamental rights chapter which was legally protected and enforceable. In contrast to the 72 Constitution, where the Chapter 6 being fundamental rights, the 78 Constitution included its fundamental rights in Chapter 3. It should be noted that this itself is a sign of fundamental rights being prioritized under the 70 Constitution. Additionally, Article 3 of the very first chapter acknowledges fundamental rights as a part of the sovereignty of the people. In the Republic of Sri Lanka, sovereignty is in the people and is inalienable. Sovereignty includes the powers of the government, fundamental rights, and the franchise. Also, Article 4D also points out that all governmental institutes respect and protect the fundamental rights of the people. In Chapter 3, from Article 10 to 16, the fundamental rights of the citizens are mentioned. There are as follows.
Well, Nashita, you can skip the rights. There's no need to read all the rights in detail. You all can read them at home. This is just a direct quote from I've quoted from the Constitution itself, right? So you can directly come to this point, the weakness and the restrictions.
The weaknesses and the restrictions on fundamental rights. All the fundamental rights of 1978 Constitution are much more powerful than the fundamental rights in 73 Constitution. Still, the rights of the 1978 Constitution also are subjected to certain reasonable restrictions. Therefore, in this chapter, also certain weaknesses can be seen. One of the most criticized weaknesses of the fundamental rights chapter is the exclusion of right to life, liberty, and safety. Despite including a vast range of different fundamental rights, these rights are not directly included in this chapter. In addition, right to property is also excluded in this chapter. However, it should be noted that the 1972 Constitution had extremely restricted fundamental rights comparing to the 1978 Constitution. The fundamental rights which were given under Article 18.1 were only available subjected to all the restrictions given under Article 18.2. In contrast, the 78 Constitution does not carry such restrictions. However, certain restrictions such as national security, emergency situations are applicable under the 78 Constitution as well. According to the 78 Constitution, the fundamental rights are not absolute or supreme. However, the reasonably effective legal procedure is established to protect these fundamental rights. The main institute which is in charge of protecting fundamental rights in the Supreme Court of Sri Lanka, as provided by the Article 17 and Article 126. A citizen may file a petition in case of an infringement or infringement of their fundamental rights by an executive or an administrative action of the government. In addition, the Ombudsman and the Human Rights Commission of Sri Lanka are also involved in handling the protection of fundamental rights. The role of Supreme Court in protecting fundamental rights, as provided by Article 17 of the 1978 Constitution. Supreme Court is given the power to handle the task of protecting fundamental rights of the citizens of Sri Lanka. Therefore, any citizen who had their fundamental rights violated or about to be violated due to an executive action or an administrative action has the opportunity of filing a petition to Supreme Court as provided by Article 126. A petition on fundamental rights should be drafted within 1 month of rights violation and submitted to the Supreme Court. Initially, the petition should be examined by 2 Supreme Court judges and should be approved for a trial. Once the petition is approved, it is taken into consideration and Supreme Court may examine the petition in a trial and deliver a judgment within 2 months. The judgment may reject the claim of fundamental rights or approve the claim of fundamental rights. If the claim is approved, the Supreme Court may order the relevant executive or administrative authority reverse the decision, or the court may grant relief to the affected party. Therefore, it can be seen that the Fundamental Rights chapter of the 1978 Constitution is more effective and practical than the 1972 Constitution. However, it should be noted that this chapter also has several weaknesses. One, this chapter of fundamental rights provide protection specifically over violation caused by executive and administrative actions. Therefore, it does not include violation caused by any law passed by the legislature. So the task of protecting fundamental rights is only given to the Supreme Court of Sri Lanka and no other court is given any authority. Three, the petition should be filed within 1 month of the violation, which might not be sufficient time in certain cases. 4, the judgment of the court should be released within 2 months, which might not be sufficient time in certain cases. 5, third parties not being able to file fundamental rights petitions on behalf of someone else. 6, the right of a citizen to seek the protection of the Supreme Court in case of right violation not being recognized as a right itself. 7, right to life not being directly mentioned.
Right, okay. So, of course, what we did was just refreshing our memory. This is a part that we have already covered, right? And if you want to further refresh your memory, like we explained all of this. We explained how going to Supreme Court works, that you have to file the petition within 1 month, and how the judges take this into consideration, right? Last week's class is on YouTube, so it's there. I normally upload the class on that day itself for you all to go check it out, or even for someone who misses the class to go watch it, okay? Right. So since you all know how Supreme Court works, of course, that there is another portion called the Ombudsman. Now, this also we discussed briefly last week, right? So this Ombudsman position, his name is the Parliament Commissioner of Administration. All right? Parliament Commissioner of Administration. Okay. So this person is like in charge of the discipline of the public sector, the permanent executive. Okay. So Article 156, Clause 1, recognize this position, but the position is established through a parliamentary act. This act was passed in 1987. After that, 1991 and 1994, in both years, this position of Ombudsman received more powers, and it has turned into a reasonably more powerful position than it used to be. Okay. So, however, it is mentioned, like, before the 17th and 19th amendments, the Ombudsman was appointed by the President as the President prefers. President could appoint whoever he wanted, right? So the President shall not appoint someone either a member of the Parliament or a staff member of the Parliament or an officer of a government corporation or someone who's from a local government authority. The President shall not appoint these kind of people as the Ombudsman, right? After that, if the Ombudsman's position is vacant by the death of an Ombudsman, or if he resigns, or if he retires at the age of 70, or if he's removed by the President because of a mental or physical incapability, or if a motion is passed in the Parliament against the Ombudsman, President may remove the Ombudsman. Okay. So after the 17th Amendment, Ombudsman cannot be appointed by the President on President's sole discretion. How do you appoint them? There is a place called the Constitutional Council, and that Constitutional Council has to recommend a person. Okay, now we shall see that when we study the amendments anyway, 17th and 19th Amendment, we have a separate lesson for that. Okay. So speaking of powers and tasks of the Parliament, right? So the Ombudsman can run an investigation, right? He can do an examination. First of all, unlike the Supreme Court, you don't have to send a petition to Ombudsman. You can send a letter. You can simply send a letter and say, you know, Mr. Ombudsman, I went through a problem like this. This government, this officer sort of did something like this and my rights are violated. Please look into this. Okay. So in this, the Ombudsman can start an investigation against that particular governmental institute or the person or the officer to see whether that person has really violated this victim's fundamental rights. Okay, so he has the authority. He can summon any public officer or any public servant for questioning, right? So he can visit any governmental institute. He can visit any ministry, any department, right? And he can say that, okay, we have a complaint, I want to question you, and summon any public servant to his office, right? And he can do the interrogations, he can gather testaments, right? And he can prepare reports and all that. But his powers have some restrictions. The first and biggest restriction is Now this person, the ombudsman, has to notify the head of the relevant governmental institute. He has to notify before coming. Now imagine I am the ombudsman. Imagine I am the ombudsman, right? Let's say in this class, I am the ombudsman. That means what is my job? My job is to make sure that your rights are protected, right? So imagine that someone comes to me, right? Let's say that Rashid comes to me. Rashid comes to me and says that there is a public officer called Tasha, right? There's a public officer called Tasha, and she made an executive decision and my rights are violated now, right? So I have to investigate Tasha's actions now, right? But I have to notify Tasha's boss before visiting that office as the ombudsman. Now imagine Tasha's boss, let's say Tasha's boss is Nashita, right? So I have to send a letter to Nashita saying, ma'am, I have received a complaint about one of your employees called Miss Tasha, and like I have to run an investigation. So I will be visiting on this particular day. Okay. So what is the problem when that happens like that? Then they have enough time to hide whatever the evidence that there are available about this case. So me running the investigation would be pointless. So I had to notify about a week back, so they have the time to hide all the evidence. So I will come and do the investigation. I won't be able to find anything. Then I have to tell Rashid, okay, Rashid, I'm sorry. It seems like none of the rights are violated. Sorry, right? Because in other countries, if you take other countries, the ombudsman have a power to just suddenly just storm into an office and do an investigation, right? So let's say if we lived in some other country like Denmark or Finland or Sweden or Norway or Iceland or some country like that, in that country, if Rashid tells me, if he gives me a complaint saying, ombudsman, my rights were violated, and like this, some officer called Tasha violated my rights, then I have the power to just walk in and like, to find Tasha and her boss Nashita will find me by surprise. I'll be like, okay, Mr. Ombudsman, what can I do for you? I'll be like, yeah, I have a complaint. I'm here to investigate, which means that you all won't have any time to hide any of those evidence, which means the investigation will be more transparent. Okay. In Sri Lanka, you have to notify before coming. There's no point in having that in the first place. Okay. So there is a problem like that. Then also there is another thing. There is an act called the State Confidentiality Act. So when it comes to certain like military related, like the Ministry of Defense and all those, so there is a list of governmental institutes mentioned on the State Confidentiality Act, and the ombudsman can't investigate those as well. Okay. So because of that, this ombudsman has sort of turned into like a powerless person. Okay. Now my mother did her thesis for her LLM on the ombudsman. She did a research on that, and I read her dissertation. So it says that the ombudsman is recognized as a toothless tiger. So he's a tiger, yes, constitutionally recognized position and all that. Yes, the ombudsman sounds like a tiger, but he doesn't have any teeth, right? Toothless tiger. All right, like that. So what are the methods to present complaints to the ombudsman? How do you present complaints to the ombudsman? Right now, back in the day, originally, the complaints had to be made through the member of the parliament. Okay, now going back to the same example, let's say Rashid wants to contact me. I am the ombudsman, right? Rashid will have to go through whoever the member of the parliament in his area, right? He can't come directly to me and give me a letter. Let's say that he's the member of the parliament in his area is Rifki. He'll have to go tell Rifki, like, Mantri Tuma, I have a problem, like one of my rights are violated. Can you give this letter to the ombudsman? Then Rifki will come and give me the letter. That's how it functions. But you all know how politics work in Sri Lanka. You all know how difficult it is to meet a member of the parliament or a minister. Right? Getting an appointment is so difficult. So this was heavily criticized. Because of that, they changed that system later on in that act in 1994. And after that, you can directly come and give your complaint to the ombudsman by yourself, right? So once you submit your complaint, okay, the party has to notify the party has to notify about the complaint within 30 days, right? Like the party has to notify to the parliamentary committee. There is a parliamentary committee for public petitions. So you send a letter to the ombudsman and you notify the parliamentary committee that you sent a letter, right? So the ombudsman has the authority to either take the complaint or not take the complaint. Now, since that Rashid has come and given me a complaint, now I have the authority either to decline that complaint or I can take that complaint. Okay. So if I decide to decline Rashid's complaint, saying that I feel like this allegation is false, I feel like this incident is explaining of Tasha making an executive decision violating his right, this sounds false. It seems like she hasn't done anything wrong, so I am not going to go ahead with this investigation. If I decline that, I have to notify the public petition committee in the parliament and give the reasons why I am declining this. If not, I can take proceedings, I can start the investigation. Okay, and this investigation, the ombudsman shall be focusing on 3 elements. First, has the relevant action of the relevant public officer resulted in a fundamental rights infringement or an injustice? Whatever this public officer has done, has it resulted in any fundamental rights violation or injustice? That's the first thing you have to check, right? Has it been a rights violation or any injustice? Has anything happened like that? That's the first thing. Secondly, you have to check whether that relevant action is against the law, right? Maybe it has violated a right, maybe it is an injustice, but still it might not be against the law, right? So second thing, you have to clarify whether the public servant has violated the law. Third, you have to check whether this action is taken in good faith. Has the person actually made this decision in good faith? Or is it like purposely done to violate rights? Now imagine that, let's say Rashid has like a small shop. He has a small shop, but it is built on the pavement, right? And let's say Tasha is like a officer in the road development authority, and she has put a dozer to all just, brave, like, what do you call that? Like, remove that shop completely, bulldozer that shop. And he is filing for fundamental rights violations now, right? Now, first of all, I have to see whether rights violation has happened. Then I have to see whether it's against the law. Has she like officially made like a proper procedural decision, or has she like just privately told the dozer guy to go and just demolish that shop, right? Or then I have to check, like, thirdly, whether this action was taken in good faith. Like, is there like actually a road project going on? Imagine like when I'm doing the investigation, I can see, okay, you know what, they were actually planning on widening that road, which means that demolishing these shops were necessary. So Tasha has made that decision in good faith. She has done that as a part of the project going on. Or as I can see, no road project going on, none of the other shops have been touched. It's just Rashid's shop have been demolished while the other shops are there. That means it's not taken in good faith. In that case, yes, there has been some injustice done. Okay. Right, now that final decision is made, the investigation is concluded, final decision is made. Now what do you do? Now the ombudsman should notify his decision and the reasons behind the decision to that parliamentary commission. Okay. Not only the parliamentary commission, there are 3 places that you need to notify. First, to the head of the relevant governmental institute, right? Now, Tasha made that decision because she's a member, she's an officer in the road development authority. I will like, okay, who is the head of the department? Nashita is the head of the department in the road development authority. So I notify her. Your officer has made a decision like this, and I have concluded there is a right violation has happened. Secondly, the minister in charge of that area, right? Let's say who is the minister of Tasha's department. Let's say Warner is the minister. I will like, okay, Minister Warner, this institute is under yours, and there's a person in this institute, she has made a decision and someone's right has been violated. So I'm notifying you. Then, of course, to the Parliamentary Committee of Public Petitions. Like, you guys remember there was a petition like this. Yeah, I did the investigation. I've concluded a right violation has happened. Okay. Then this final report may suggest something like this. First of all, either you can say to invalidate the relevant action of the public officer. That means like cancel out. This depends on the case now. In this case, in this example I use, this can't be applied because once a shop is demolished, you can't just undo that, right? So it could be something like this. Like it could be something else. If it is like a reversible decision, I may recommend to invalidate that action. Okay. Secondly, to change the relevant action, either I can say, okay, you know what? Change this action. Why don't you change this action? You can't cancel it. Okay, then change it. If not, you can change the factors which resulted the relevant action. Now you can see that, okay, you all had to demolish Rashid's shop because like there has been a road going on and you have to widen the road. And for that, you have to take, okay, then I'm going to look at it and be like, okay, you all can widen the road from the other side also, right? Because other side, there are no shops. Other side is just an empty land. Why don't you all take whatever the meters you want for the road from the other side? Then you all can leave these shops alone. You can change the factors which resulted the relevant action, right? Or you can say provide reasons for the relevant action. I'll be like, okay, Tasha, give me reasons why you specifically demolished Rashid's shop. Give me reasons, right? Or else I can try like, can you reconsider the relevant action? Tasha, can you reconsider demolishing his job? Try to find something, some other way. Reconsider this decision. Can you let him have his shop? Can you try to get the road widened from some other way? Can you reconsider this decision, right? So any of these can be suggested in Ombudsman's report. Now, first of all, keep in mind, Ombudsman is not a judicial institute, right? Now, if Rashid went to the Supreme Court, and if the Supreme Court told you to, invalidate the decision, you're bound to do that, right? Tasha, you'll have to reverse your decision because the Supreme Court telling you, because if you don't do that, you're in trouble. Even your boss Nashita is in trouble. Even the minister Warner will also be in trouble because it's a court order now, and you all are supposed to do that. Okay. Now that I am the ombudsman and I'm not a judicial officer, you all are not legally bound to do what I'm asking you to do. It's not like I can put you in prison if you don't do what I say. But if you disobey the Supreme Court, they'll put you in prison. Okay, for disobeying a court order. Now I've sent you the report, I've given you the recommendation. You all can ignore, avoid what you are doing, and I can't put you in prison. What can I do now? Imagine you all are neglecting and you all are avoiding my recommendation. What can I do? I can go and complain to the president and the parliament. I will send a report to the president and the parliament saying, this particular officer called Tasha and her head called Nashita in this department, and the minister, this is under Minister Warner's ministry, they have been neglecting my recommendations, and I go and complain it to the president as well as the parliament through a report. Okay, then the president will talk to you all. President will tell you all, okay, you know what, do as what the ombudsman says. That depends. I think if you guys are friends with the president might not, right? So it's all up to the politics. But ideally, president can make a decision from that point. After that, ombudsman is free. Like, then Rashid will come and ask Mr. Ombudsman what happened. They'll be like, okay, they didn't really follow what I said. I told the president, let's see what the president does. Okay. Right. Then you can see the criticisms. Why do you criticize the ombudsman? What's wrong with this ombudsman position? First of all, the first issue is the ombudsman being a solitary position held by a solitary person. There's only one ombudsman for the entire country, and that is not enough, right? Imagine being the only person, like being solitary person in a country where you have 23 million population, being a solitary person who's there to handle fundamental rights cases. The person gets like hundreds of letters every day, right? And he only responds to some of them. By no means the ombudsman alone is capable of handling all these complaints on his own. So some have suggested to establish an ombudsman office in each district, right? Okay, have one ombudsman for the entire country, but at least put a deputy ombudsman to each district, so you can take control of the cases in each district, right? Also, another problem is in practicality, Ombudsman is a very inefficient person, right? Now, I'll just tell you something. They don't write this in the answer. Normally, the Ombudsman is always a retired government officer, right? Someone who's retired. So normally what happens is because the president appoints, right? So the president, one of president's friends who has been working in the public sector and who has retired now, they are eyeing this position. Now imagine that, let's say Warner is running for president, right? And by the time Warner runs for president, he'll be like what? He'll be like 55 years old, and I'll be like what, 65, 67 years old, right? So I have just retired from my government position. So I know that Warner is running for president, and let's say Warner wins, and he's the president now. Now that I am a retired person and I'm friends with Warner, I'll be like, here, Warner, son, can you put me as the ombudsman? It has turned into a position where like these old people sort of like get a position where you don't have to do a lot of work, but you get a good salary and you get a respect for being a constitutional officer. So I'll be like, oh, okay, I'm a constitutional officer, then I can show off to like people, I will still be respected and I get a good salary. And I receive like hundreds of letters every day. And like, if I feel like I respond to 2 or 3 of them and not do any work. So because of that, the ombudsman service has become very inefficient in Sri Lanka. So much so, I bet like there are what, 16 people, excluding me, there are 15 people in this class. I bet more than 10 of y'all did not know that there was a position called ombudsman in Sri Lanka until I started this lesson. I bet. I am certain of that, right? People don't even know that there is a position called the ombudsman. They know Supreme Court works. They have heard the Human Rights Commission here and there. The ombudsman word itself sounds weird. People don't know that there is a position because the ombudsman hasn't been doing any work, right? Has been very inefficient. Then thirdly, of course, the lack of power on investigations, as it suggests, like being a toothless tiger, right? So not like in European countries, the ombudsman does not have the authority to run investigations like by just barging into officers. Like he's an investigator, he should have that power. The fact that you have to formally notify prior to an investigation, it completely ruins the success of the investigation. Like no truth comes out. Who is like stupid enough to like have been notified by the ombudsman is coming next week and just to leave the evidence out on the desks? Everyone just like gives them the preparation time to sort of like face the investigation better, right? And of course, the power being limited to recommendations and not having any legal authority, judicial authority to sort of like push for his recommendations to be empowered, like implemented. Okay, these are the reasons. Then we need to move on to the Human Rights Commission. Then we'll see how the Human Rights Commission works in Sri Lanka. Until that, do you guys have any questions? If you guys have any questions, you all may ask. Other than that, you all may make a small short note. Yes, ask.
Who is the current ombudsman in Sri Lanka?
Current ombudsman. One second. Amma, දැන් ඉන්නේ ombudsman කවුද අලුත් එක්කන? චිත්‍රසේන නේද? Yeah, it's a Mr. Chitrasena Pereira. He used to be a public servant. He used to be a judge, I think. Yeah, he used to be a judge. He's a former judge, Mr. Chitrasena. I think my mother went and spoke to him about this, what do you call it? About this, about her thesis. So yeah, casually, nothing against him. I just said that they are very inefficient and all that, but like nothing against him. But that's how it has been going on. Okay.
Sir,
Yeah, ask.
sir, if the ombudsman has a case and it is still going on, if the president stays, if get to know, will the president know that, sir? The case is in ombudsman's hands, so it's going on.
Officially, no, Rashid. Rashid, it was you who asked, right?
Yes, sir.
Yeah. Now, officially, there is no process for the president to be notified when the ombudsman start a case, because it is only notified to the parliamentary commission. But depending on the status of the case, now imagine that this is going against, now currently our president is Gotabaya Rajapaksa, right? And you have Basil Rajapaksa as a minister, or Namal Rajapaksa as a minister, who's like a family member of the president. So if you are sort of like going for a fundamental rights case against one of their ministries, the president will get to know unofficially. Officially, there is no process for the president to get to know. President will only be notified if the ombudsman specifically notifies him saying that, they are not following my order or whatever, right? Other than that, not president doesn't come across, right? Well, you guys must have heard, I don't know whether the students who are familiar with Sinhala here and the students who are familiar with the Sri Lankan folk stories, you all have heard of a position called Duggannarala. Duggannarala he's a songwriter in Sinhala, he's not him, right? Duggannarala is a position that the king had appointed. People used to come to the ancient castles. All right. So his name is K.T. Chitrasiri. Okay, if any of you all want it for the general knowledge, K.T. It's a K.T. Chitrasiri, right? Used to be a high court judge. So anyways, back in the day that there was this system like people from all over the country comes to visit the king and complain about whatever the injustices they faced, right? And the king is busy. King doesn't have the time to be listening to all these complaints by people. So the king appointed one person called and said, you are the Duggannarala, right? So please listen to people's complaints and handle them if it's possible for you to handle. If there's anything you can't handle, let me know. I'll look into it, right? So in Sinhala, if you're familiar with Sinhala, Duk means like sadness or complaints, right? Duk means like sad stories. So he's a Duggannarala. He's the person to hear your sad stories, whatever the injustice and stuff you have, right? So he was there to sort of like listen to the people. And it is the same concept that we have used here. Because the president can't be looking into all the fundamental rights violation cases in Sri Lanka, he has appointed the ombudsman. Tell the ombudsman if you have a problem, he'll look into it. If there's anything, he'll let me know. Right? That's the whole idea behind the position of the ombudsman. Right? Okay. Any other questions, guys? If you all have, you all can ask, or you can put it in the chat box. Or else, take a couple of minutes, like 2-3 minutes, and put a small short note, and we'll start at 7:10. Right. Now that we discussed about the ombudsman, we've discussed about two options. If your rights are violated, we discussed about two of the options that we have out of the three. First option was going to Supreme Court. Second option was going to the ombudsman. And now we have a third option, which is going to the Human Rights Commission, right? So the Human Rights Commission also has a role to play fundamental rights in Sri Lanka, right? So Human Rights Commission was established in 1996, right, under the Human Rights Commission Act. Okay, so according to this original constitution, this commission is appointed by the president, right? And this commission has an official tenure of 3 years. Also, this position, like a member could be, the membership could be vacant due to death, resignation, complete of tenure, or removed by the parliament with an absolute majority. That means that once a person is appointed by the president to this commission, he's there for 3 years. So he might complete the 3 years and be out of the commission. He may resign, he may die, or the person can be removed by the parliament with an absolute majority. What is the absolute majority in the parliament? 113, right? Not a majority of whoever that is present on that day, majority of everyone. Okay. However, okay, there's a typo here. 17th and 19th amendments. 17th and 19th amendments, after these amendments, the commission just cannot be appointed by the president on his own. Just like most of the appointments, the president has to appoint someone as recommended by the Constitutional Council. Okay. So the section 10 and 11 of this Human Rights Commission Act provides what sort of powers and tasks this commission has. Now, first of all, the first main task this commission has is to examine complaints on fundamental rights infringements and close to be infringed, right? Now, when you were reading the Supreme Court note also, you saw that you could go to Supreme Court or you could go to the Ombudsman, either when your rights are violated and when your rights are about to be violated, close to be violated, right? Imminent infringement, you remember there was a word called imminent infringement. Either when your rights are infringed or imminent infringement, that means close to be infringed. Is it like now in Rashid's case, either his shop has been demolished or he has received a letter saying within 1 week your shop will be abolished. Get ready. That means it hasn't been violated yet, but about to be violated, imminent violation, right? So the commission has also authority to provide recommendation on in such cases. First of all, what they do is to settle cases, to settle. The first thing they do is they attempt to settle. Now, going back to the previous example, who is the complaining party now? Complaining party, the petitioner's side. Rashid is the petitioner, says that my rights are about to be violated. Who is the respondent? Tasha should be the respondent because she is the one who made that official executive decision. As a part of the permanent executive, she made that decision, right? And she is working under Nashita. Nashita is the boss of, she's the head of the Road Development Authority. And they come under the Minister Warner, who is a part of the political executive related to this matter, right? So those three will be the respondents. So what the first thing the Human Rights Commission would do is they will call a meeting, okay? So Rashid can come. Rashid and Tasha will have to come because they are the direct parties. Nashita and Warner don't like, they can send their representatives. They say like, you know, I will send my lawyer or I will send someone who works for me. Right? They don't have to come because they are not directly connected. And they will try to settle it. They will like, okay, what's going on? Why do you have to remove this shop? Okay, Tasha will be like, okay, we are fixing the road. We'll be like, okay, is there a way that you can save this shop and like, you know, take the space you want for the road from the other end? Something like that. Okay. So this includes, as you mentioned, okay, the executive and administrative action, whatever the action that you took, or there could be any action taken under the Prevention of Terrorism Act. Okay, this is a little too deep, but I'll tell you all, right? There is an act called Prevention of Terrorism Act. Now, this is, I'm going towards the law side from the political science side. For you to, it's enough if you remember, it's an injustice that has happened because of the executive or an administrative action or the Prevention of Terrorism Act. I'll explain how Prevention of Terrorism Act works, just using whatever the legal knowledge I have. Now, you guys know, there is a normal law that applies to Sri Lanka, like evidence law, how you handle evidence. But when the Prevention of Terrorism Act is involved, some of these laws change. For example, if you give a confession to the police, that is not valid. Okay. This was decided in a case in 1956 because the problem was, you know, that sometimes the police tend to torture you till you give a confession saying, yes, I did kill, I did rob them, right? They torture you. Maybe you haven't done it just because of the torture. Out of all the torturing you have to go through, you may confess, right? So they've just covered that for the police to take an easy way out, just, you know, arrest someone, torture the person until the person confesses. I'd be like, okay, any confession done in a police station, any confession done to a police officer is not valid. Okay, that is a general evidence law in Sri Lanka. All right, confessions done to a police officer or in a police station is not valid, but they've given an exemption under the Prevention of Terrorism Act, where in that case, if the person is arrested regarding any activity related to terrorism, a confession given to someone above the rank of ASP, if you given a confession to a police officer above the rank of ASP, right? Then that confession is valid. So as you can see, some of the general laws you have in this country, when it comes to the Prevention of Terrorism Act, it is different, right? It gets an exception. For example, when you arrest someone, the maximum number of hours they can keep you in custody without, you know, showing you to a magistrate is 24 hours. If they arrest you right now, it's 7:19. 719 on 3rd of September, right? If a police officer arrests you right now, right, they should show you to a magistrate, and a magistrate put you in remand before 719 on the 4th of September, before 24 hours. If they keep you in prison, if they keep you under arrest without showing you to a judge within 24 hours, that means that your rights are violated. But again, that can change under the Prevention of Terrorism Act. If you are arrested regarding some activity related to terrorism, they can keep you for longer, right? So the problem is the police have been using this Prevention of Terrorism Act sometimes when they have to arrest someone, when they don't want to show them to a judge, or when they want to get a confession. They just file whatever he did under the Prevention of Terrorism Act, and they'll be like, okay, he confessed to us and he's connected to terrorism, so this confession stands, like that. So there have been cases of the police sort of misusing this law, and as a result of that, the Human Rights Commission does address these kind of problems as well. Okay. So here also, you can see that fundamental rights infringement, of course, that you have to go to the Human Rights Commission. Again, you have to make the complaint within 30 days, just like going to Supreme Court. Okay. Then the commissioner has the power to resolve matters by mediating the parties. As I showed you before, they try to settle the matter through mediation by calling the two parties. Let's try to figure this out without going into any court proceedings or whatever, right? However, when the mediation is unsuccessful, they can take these options, these following options: recommending the relevant parties to take legal actions by following court procedure, right? Okay, now Rashid came to me and said that, okay, you know, this officer called Tasha took a step to, you know, get rid of my shop and my rights are violated. Then I'll be like, okay, let's try mediating. As a Human Rights Commission, we want to mediate. We ask the both parties to come. We try discussing. Okay, it doesn't work. Then I will recommend to Rashid, mediation didn't work. I will recommend you to go to courts, go to Supreme Court. Okay. Then sending the relevant case to a judicial institute directly. If this is like a really bad case, like a really serious case, I'll be like, Rashid, you stay. I will send this to the Supreme Court. As like, so the commission can appear for you, because if this is like a shop being demolished is something, but imagine this is something like really, really bad. Okay. In that case, I'll be like, okay, this is a very serious case. You know what? I will appear for you. Now imagine the police have been like, you know, beaten you up, broken your bones, and like, you know, something like that. Then there's like, okay, you know what? I'm just not going to recommend you to go to courts. I will go to courts. Like, we will go to courts as a Human Rights Commission, and we will appear on behalf of you, right? Then providing necessary recommendations to relevant officers in order to prevent the violation. That means I can give recommendations to Tasha here. Be like, okay, Tasha, I will recommend you as a Human Rights Commission. Why don't you make a decision like this? Why don't you fix the road in the other way, right? Again, going back to the same next one, preventing recommendations to reconsider the actions. Why don't you reconsider this action? Okay. Or reconsider the factors behind. Okay, you want to fix a road, right? But you don't have to fix the road from here. You can fix a road from this other side also, if you look at the map, right? Why don't you reconsider the factors behind this decision, right? Or else I can be like, about neglecting, right? So I can take, imagine if it's a case that someone hadn't been taking actions. Think of a different case. Now imagine Tasha works in the urban council, right? And she works she's the in charge person about like garbage disposal in the urban council. And imagine Rashid's house, in front of Rashid's house, there's a garbage dump. He had been telling Tasha to, you know, ma'am, can you please address this problem? There's a garbage dump in front of my house. Can you get rid of this? And she had been neglecting that for months. Now he comes to me and says that to the commission, okay, my rights are violated. I'll be like, okay, Tasha, you have been neglecting taking actions, right? Please take necessary actions and, you know, get rid of this problem. Okay. Then, notifying the relevant public officers to provide reasons behind the actions which resulted in violation. I can say like, give me reasons, Tasha, give me reasons why you violated his rights. You should have like legal grounds. Okay. Once the commission provides such recommendation, the relevant public officer and the institute shall be given a certain time period to follow the recommendation. That means like, okay, Tasha, I have given you recommendations. You have 1 month or you have 2 months, depending on the action, right? You have 2 months or 2 weeks to take actions and show me. Then after 2 weeks, the commission will do an investigation. And of course, if you haven't taken enough adequate actions, the commission shall send a report to the president saying that, okay, there's an officer like this, haven't taken, we have given recommendations, but they haven't taken enough actions, right? So other than that, there are other duties also they do, like Human Rights Commission, other than taking such actions, they do other activities as well. Okay, now for example, observing and being cautious on executive and administrative procedures to assure fundamental rights, like whatever the laws, what are the laws they pass, what sort of circulations that these people pass, like the president and all that, are they like sort of attempting to violate rights of the people? You have to be cautious, observing people, right? Then taking necessary steps to settle cases of rights violation through mediation, as I explained before, right? Try to mediate between the parties. Providing consultation and support to the government in order to make procedures and promote fundamental rights. Now, we can go and provide consultation and we can support the government. We can tell, okay, now Warner is a minister, right? So Warner is planning to bring a new bill, new law. They'll be like, okay, Minister Warner, you can consult us. We'll support you how to make your law in a more protective manner to protect fundamental rights. Like, send us the bill. We'll go through it and tell you, these are the areas that should be changed. Providing recommendations to the government with regard to international steps to be taken. Sometimes, now Minister Warner is a minister in Sri Lanka. He might not know much about international human rights law, right? So he can be like, okay, Minister, there are international laws like this, right? If you have to keep up with those, your law have to be changed this way, because the Human Rights Commission, they are experts of the international human rights law, right? Then improving education on human rights and raising awareness on human rights. Like you see that sometimes you get those small pamphlets, you see some of those posters, like, telling you about the rights. Those Human Rights Commission runs those. They use their funds to raise awareness about human rights. Then they can establish subcommittees on regional levels. Like you can have a small committee, small Human Rights Commission, subcommission in Monaragala, in Anuradhapura, like in the other areas, grassroots level. So they can go to the lower level and help people, right? And of course, when a fundamental rights case is a trial in the judiciary. Now imagine Rashid's case is in the courts, right? So with the approval of the relevant court, we can go and help that proceedings. We can go and be like, Honorable Your Honor, we can go and talk to the judge and Your Honor, we are the Human Rights Commission. Is there anything we can do about this case? Do you want us to help with the proceedings? Do you want us to provide material? We can go and help, right? So that's what the Human Rights Commission does. Right, I have a question. So are the members in the Human Rights Commission legal attorneys? Most of the times, yes. There's no rule saying they should be attorneys, but most of the times the members who are appointed there are attorneys who are specialists in human rights, because then only that they have the knowledge how to handle these matters, right? Because you have to work with the courts quite a lot. Most of the times the attorneys working in the Human Rights Commission are attorneys, yes. Okay, right. If there are any other questions, please put them in the chat. Other than that, again, it's time for you all to make a small short note. And after that, there's a small lesson that's there, the amendment process. We'll look into that, right? You have 7 minutes. Make a short note about the Human Rights Commission. If you have questions, you may put it in the chat. All right, I have a question. So are everyone appointed by the president? Yes, members are appointed by the president. Right, it was there in the note. There you go. Right, the members of this commission were appointed by the president for an official term. The difference is original constitution, like originally the president single-handedly appointed, president appointed whoever he wanted to this commission. After the 17th and 19th amendments, all those appointments had to be based on the recommendations of the Constitutional Council. Then the Constitutional Council had to recommend people. President could only appoint them. Right, you have 6 minutes. Make the short note, then we are moving on to the last part. Right, now what we have to study is the amendment process of the 1978 Constitution. Now, speaking of which, first of all, the 78 Constitution is a rigid constitution. Now in Unit 4, we learn what's a rigid constitution and a flexible constitution. If the constitution can be amended very easily, it's a flexible constitution. If the constitution requires a very hard, complex, long amending process, it is a rigid constitution, right? Now our constitution is rigid, okay? But when we study it further, we can see that some articles are extra rigid. Now let's find out what's going on. Now, first of all, the 78 Constitution has two amending processes. Okay. So when it comes to certain articles of the constitutions could be amended with a 2/3 majority of the parliament. Simple as that. 2/3 majority. Now you have to notice this is not a 2/3 out of whoever's present that day. Yeah? It's not like you have 90 members present on that day. If 60 of them are okay, you can amend the constitution. No, not like that. Not a 2/3 like that. 2/3 out of the 225 total number. Right? So you need 150 members in your favor. That's a 2/3 including the total number of members in the parliament. Okay. So as long as you have 150 people in your favor, that you can amend the constitution. Okay. As I was explaining, you need a 2/3 majority out of the total number, out of the 225 members. If you have 150 in your favor, that's a 2/3 majority. Now, the current parliament has a 2/3 majority. Gotabaya's government has a 2/3 majority, 150. So if you have that, certain articles can be amended. 2/3 votes in favor, it is amended. But there are certain articles in the Constitution. Now, they have to be passed with a 2/3 majority, just like the first step. Right, and there is a second step also. What is that? It requires the approval of the public in a referendum. You have to call for a referendum, and the public has to give you the approval. Now, what are these articles? 1, 2, 3, 6, 7, 8, 9, 10, 11, 30, close to 62, close to. These are the most important articles of the Constitution. And these articles should be amended with a referendum as well. Now, Article 1, 2, 3, of course, the name of the country, flag of the country, national anthem of the country, right? Unitary status of the country. These things, if you want to amend these things, you need a referendum, right? First, you have to get it passed in the parliament with a 2/3 majority. Then you have to call for a referendum and get it passed in the referendum as well. All right. So these articles are extra rigid. Now, first of all, getting a 2/3 majority in the parliament itself is difficult. Why? Because Sri Lanka has a multi-party system. On top of that, we have the proportional electoral method, which means it's very unlikely for a government to reach a 2/3 majority. Okay. Now, if you analyze our history, right? The very first parliament, J.R. Jayawardena had a 5-6 majority. So because of that, out of the 20 amendments we have in our constitution, 16 of those 20 amendments came in the first 10 years alone. Within the first 10 years alone, all these came. Okay, that's because there was a majority. Since then, it was very difficult to find a 2/3 majority, which is why since 1988 up to 2021, which is like almost like 32, 33 years, there have only been 4 amendments. Okay, so we can see that the Constitution has 20 amendments, but none of these articles have been amended thus far. Okay, we have been following this to amend certain articles, first method, and we have 20 articles in the Constitution. Okay, so I included a list of amendments also. First amendment. These, of course, these for your further knowledge. We don't need to study all these articles. These for you all to have the basic idea of what each amendment is about. In fact, what we have to study under the syllabus is the 13th amendment. That's where the provincial councils were established in Sri Lanka. Then 17th, 18th, and 19th amendment, where they dealt with the powers of the president. Right? 20th amendment was passed recently, so hence that is not there in the syllabus yet. We will be touching on that also, just to be updated. Okay. Other than that, none of the other amendments are there in the syllabus, just for your knowledge. All right. Okay, so we'll just read this and we can conclude that. It's nothing much for you to understand. Yes, you can see, I don't think you all will get a writing question from this because very little to write. Most probably you all will get an MCQ about the amendment process. All right. Okay.